as lawyers, we're in a service industry. I'm a patent attorney. I work at a company called Clarquist Sparkman in Portland, Oregon. And we do, patents, trademarks, copyrights, and we do the prosecution and litigation and all that. But we are a service industry. At the end of the day, we do what our clients tell us to do. And one of the dangers in being a lawyer is that you start thinking that, you're the one running the show. And that's not the case, right? We're in a service industry. We need to listen to what our clients tell us and learn how to respond. And so one of the big things that's come up now is costs. It's nothing new. It's certainly been on people's mind since the beginning of intellectual property. But right now, I find that there are a lot of lawyers who are really good lawyers and really focused on the legal aspects, but they're not taking into account the cost aspect. And that's understandable. Lawyers get into the practice of law because they want to practice law. But part of what we need to also do is to control costs. And it's not necessarily a negative thing. It's actually a positive thing because it fits in with what we're already doing, which is we're trying to achieve our clients' goals. And so if you want to be a successful IP professional, one of the things you have to do is control costs. And so from my perspective, one of the things I'm looking at is controlling costs of patent prosecution in the United States. So let's get started. This presentation is licensed under Creative Commons. The idea here is to get the IP awareness up, to spread the information. So I'm not trying to protect this presentation. I would actually encourage you to make copies of it and distribute them, if anybody's interested. It'd be actually surprising to me if there's anybody who's interested enough to make a copy, but if you are, you're certainly free to do so. So I'd like to start, this is what we'll be talking about today. First, the cost control concepts, right? So the idea there is that as lawyers, we have a vocabulary that we use to describe legal issues, and we're very familiar with that. But oftentimes, we don't have the vocabulary we need to talk about cost control. And so we'll take a quick look at that and some ideas and some concepts that will help us talk about this. Then we have finding the inventions, right? So for those of you who don't know anything about patent law, which is probably almost nobody at a conference like this, but if you don't know about patent law, you get a bonus in this presentation. Not only are we going to talk about costs, but we're going to talk about the timeline of patents, okay? We're going to talk about cradle to grave of patents. So if you follow along, you can kind of see the lifespan of a patent because we have to consider the entire life cycle if we want to control the costs. So we'll start with finding the inventions. This is sometimes called harvesting. And it's actually very challenging sometimes the IP might be generated, but we have to find it, right? So that's part of the process, and there are costs involved with that. Then there's filing on the inventions. Of course, we file patent applications, and there are costs associated with that. Then we have the prosecution, which is the back and forth. I like to call it the table tennis, right? We file the application, then the examiner comes back with a rejection. Then we have a response, then we come back with another rejection. 95% of the applications that we file are rejected. So you have to sort of plan for that process. And in certain cases, it can be rejected multiple times, and that can add to the cost, and we have some strategies for addressing that. And then post-issuance. There are some things that we can do after the application issues. There are a few administrative matters here and there. And then there are the dreaded maintenance fees. How many people here have had to do pruning of a portfolio, right? Because the portfolio gets very large, and then we have to pay all these maintenance fees, and we start asking ourselves, well, why did we even get this patent in the first place? We're not using it. Why are we paying thousands of dollars in maintenance fees when the patent has no value? So that's another aspect, and that's what we'll be talking about from cradle to grave today. So the theme I have today is that there are some cost reductions that we can do that will actually that will lower the quality of the patent. But there are some that won't lower it very much, if at all. And there are actually some situations where you can lower the cost and you end up with a higher quality patent. So the idea here is we're not going to blindly go in this. I mean, the risk here is that I'm standing up here and trying to tell people, oh, here are ways that you can cut the legal fees. And that's true to some extent, but really what we're trying to do is we're trying to do it in an intelligent way, and we're managing risks, right? So we're going to cut some costs here, but we're not going to do it blindly. We're going to do it in a way that has results, but hopefully doesn't affect the quality too much, or if it does, we do it in a rational, controlled way. That's why I call it cost control, not just cost reduction. Okay? So here's some of the concepts. Concepts are setting clear goals. So this becomes almost cliche now that an attorney needs to know the client's goals, but it's absolutely true. We need to know our client's goals. If we're prosecuting a patent for one client, the goals are going to be completely different than from another. So the spectrum is, I just want a patent so that I can say patent pending on my marketing materials, which doesn't cost a lot, all the way up to the pharmaceutical who knows that their patent will be challenged the day that it issues. So there's a range in there. Most folks are somewhere in the middle, but we need to know what that is, and we need to stay in touch. And I think it was very rightly said earlier that keeping the communication lines open between the patent professionals is one way of achieving that. Being open, being able to be honest with your patent professionals and telling them, look, this really is a pain point for me, or what have you. Okay, so that's the type of thing that can really sort of serve as a context. There's cost versus risk. Well, I already talked about that a little bit, so I'm not going to spend a lot of time on that. That's just weighing, right? And then I like to divide these things into two big categories. So for those of us who are lawyers, there are procedural matters, right? There's civil rules of civil procedure. We have to comply with those rules. Well, in the cost arena, there are similar things. There are certain things that you have to do. And so you can reduce the costs on those. And in fact, maybe you can reduce them more easily because you're doing them on a regular basis. And they're sort of not very legally related. They're more procedurally related. Like, for example, you have to pay the filing fee. You have to, file certain signed documents. You have to do a power of attorney. You have to do these things. These are simple rules, though. The more complicated part is when we address the law, when we get into the substance, right? Particularly when it comes to patent applications, because for every patent application that we file, we need to do these 4 things that are listed here. This is fully understanding the invention, fully understanding the prior art, right? Because you can't just draft a patent if you don't have a knowledge of what's already been done before. Fully describing that invention, so we sort of serve as translators. We take the documents and the information that the inventors give us, and we transcribe it into a patent application. And then we have to actually write the claims. And this is a very difficult process here. I mean, typically, in our firm, if we're going to be drafting a patent application, we can spend 20, 30, maybe more hours on a patent application trying to put all this stuff together. And there was a person at one of the conferences I went to earlier in the week who was talking about AI will eventually do this, and all the lawyers will be replaced. Well, maybe one day that will happen. But think about the inputs to the AI. That's the most important part, right? Once the AI can get the inventor to relax and tell the invention and all that, then the AI will be successful. But right now, we have the problem of the inventor is very busy, all these things, and we have to get the information out of them. This part is the part that drives the cost control people crazy. Because if you keep trying to lower the cost, eventually what happens is there's a cliff. If you go too low on the cost of preparing the patent application, one of these things is going to go away, and the quality of the patent is just going to drop right off. Right? If you don't understand the invention, and we've all read patents where it's clear that the drafter didn't understand the invention, you're going to have a hard time claiming it properly. So these parts I don't have a lot of answers for you on, but we can certainly look on some of these things to try to control things. And this other concept that I like to talk about is called Credence Services, and that is, do I ever know what value is provided? Do I know the quality of what I have? And at first, certainly if you're just entering into the patent world, it's very difficult to tell that, right? So one of my law professors called this Credence Services. And what she was talking about was there are some things that when you buy them, you know what the quality is before you buy it. You can look at it, you can kind of say, okay, I know it has this particular brand name on it, I know what it is. There are some things that you don't know what the quality is until after you buy it. And that could be someone painting your house, for example. It's really kind of hard to tell how that's going to look once it's painted. You can try some things, but eventually at the end of the day, the work needs to be done before we can figure it out. Now, with patents, sometimes you don't know the quality even after you pay, right? You paid for this thing, you get it. We really have trouble measuring the quality. We've talked about patent valuation, and that would be one way, but that's sort of an expensive way to figure out the quality if we're just doing it for that exercise. But over time, of course, we will learn, right? Especially when, the C-level executive comes to us and says, what do we have on X? That's when you learn what you have, what quality you have. And so it might even not be the individual assets, but how those assets are distributed, right? So this is just some concept I think that's important because it's very difficult to measure the quality. So how do you make these informed decisions? And then you need to revisit your goals. Everything is subject to an exception. Again, I'm the attorney. I like to think I know what I'm talking about, but the client has the bottom line, has the final say. We have some clients who require us to do something that other clients forbid us from doing. So that's just the way it is, and we have to learn to live with that and meet those goals. And then looking ahead and being nimble. Can I change my patent strategy? Can I turn the corner quickly? I mean, I can cut the cost to the point where I don't know what's going on, and then I'm asked to change, and I can't do so. So, we would want to be able to intelligently, for example, prune is something that we need to be able to do. I'll go through this pretty quickly here. Finding the inventions. You can give an incentive to an inventor. There's a cost associated with that. You may want to stage it, right? You may want to have some monetary incentive when the application is filed and another one when it issues. You may not need monetary incentives in your business, but you may, and that's a cost. But of course, the benefit is that you get more inventions that are protected by patent. The Patent Review Committee. Typically, when an organization gets of a certain size, there's a committee that looks at these things as they come in. So the inventor provides the widget. It comes in as the invention disclosure form, and then we decide whether or not to go forward with that. One of the things that can be a problem there is that the committee just sort of pushes things through. Shouldn't do that. The committee should spend some time because there is a risk here that we're throwing resources away. One of the ways of controlling costs is controlling what we pursue. Don't pursue everything. We pursue things that align with the company goals. This is typically an internal thing that maybe I'm asked to give some opinion on, but typically it's done internally within the organization. Combining multiple inventions into one application. This can be a problem. We're oftentimes asked to do this, and I like to say this is sort of like having a cup and pouring something into it, and then the cup is still full, and now you're asked to pour another portion into it, and it just sort of overflows and we don't get it all. Because remember, we have to understand the invention, we have to understand the prior art, we have to describe the invention, and we have to write the claims. And so I understand there might be a limited budget, but let's be careful if we try to combine four inventions into one application, because most likely some of that stuff's going to be lost, right? And so let's try to have some focus. Let's try to focus on one idea per application. We'll continue to do it as attorneys. We'll do what we're told, but just pointing that can be a problem. And then there's searching. Certainly searching can be very helpful, depending on what type of environment you're in, to knock out inventions, right? We have 5, 10 things, and we knock out some percentage of them. That has just reduced our costs. And it probably increases the quality of the patents that we get. So we spend a little bit on searching, we knock out some inventions, we file fewer, we save some, and we end up with higher quality applications because we have some knowledge of what the prior art is. So I highly recommend searching. We have some clients who don't do any searching, but that seems like that there's some significant risks there that you're sort of throwing money away. And then filing on the inventions. Now here I'll stop for a minute, because if you don't hear anything, please hear this part. These are the filing fees. These are things that you don't need an understanding of the law. These are things that even if you don't know anything about U.S. law, you can know about the fee structure. And it's available on the USPTO.gov website. So you just type in USPTO fee schedule, and boom, there's the page. And now what I'll do is I'll sort of summarize what's on that web page for you so you can get an idea. If you're a patent professional and you're looking at filing applications in the United States, here's one easy way to reduce your costs, and it doesn't necessarily have any impact on the quality. First is excess claims. Okay? You get 3 independent claims, 20 total in the United States. If you file more than that, you pay excess claims fees. And how much is it? I think it's $420 for every excess independent claim and $80 for every excess claim in total. So if you have 3 and 20 that you get for free, if you file a 21st claim and it's an independent claim, that's $500 extra that you're spending. And you might say, well, I'd like to have that extra claim. Fine, except that if you have a number of independent claims in the application, I like to say the U.S. government thanks you. They thank you for paying those fees, but they probably won't actually examine those claims because they'll divide the case into pieces, right? And so there are ways that you can avoid doing that. So if you're going to put in all those claims, be careful because you could just be throwing money away. Multiple dependent claims, the fee on that is like $700 and some dollars. Why spend that? Why spend that? Again, the U.S. government will take your money, but essentially it's just the math just doesn't work out. It's better to get rid of the multiple dependent claims and just write them out singly. Page counts. Here's the most expensive page you can have is the first page that goes over because you pay $400 for the extra pages, and if you file an application that has 101 pages, you just paid $400 for that one page. So why do that, right? Why not reduce the font down? And that's the sort of simple thing that you can do in a case like that. There are also, as I'm talking about these fees, there are small entity discounts and micro entity discounts. We're talking about 50% and 75% discounts. So you should know if your clients qualify, and you can go to the USPTO website. There are very helpful guidelines, and even the form that is on there that you can fill out to qualify for micro entity status. And institutions of higher learning can qualify for that status and certain other organizations, and then you end up getting this huge discount on the fees, which your client will be very happy that you did, and you get the same level of service. You're not getting a lower quality patent, you're getting the same quality patent. Then you have declarations. We oftentimes get applications where we're asked to file and we don't have signed declarations. Well, that adds to the cost. And it adds to the logistics, and it's going to increase the cost, and for what reason? Powers of attorney, we can reuse powers of attorney. So this is a situation where if we're filing applications over the course of several years, we can get one power of attorney and reuse it again and again. And then there are these details that I won't get into too much, but essentially we just need the inventor family and given names. We need the resident city and the country. Otherwise, we have to go back and get it later. We have to try to file another paper or whatever. So if we have that information when we file, it's much easier to do it. And highly encourage everyone to use electronic filing system. Hopefully, whatever attorneys are working on the patent applications are doing that, because otherwise papers get lost, things get delayed, it's more difficult and it just adds to the cost. And then you have prosecution. We have several clients who are telling us to just ignore the pre-grant publication. There's a risk there. If there's an error in the pre-grant publication, you can lose patent rights. But many of our clients say, you know what, you're filing electronically, the chances of there being a page missing is kind of low, just don't even look at it. That's a rational thing to do in certain patent portfolios. Bracketing the invention, this is what we use this technique on a fairly regular basis to reduce the costs and avoid final office actions. And that is, you file your broad claim, claim 1. But then you also file a very narrow independent claim. It doesn't need to be very narrow, but narrower, and something that you would be happy to get. And the reason we do this is that theoretically, examiners are supposed to look at all the claims. In our experience, the examiners look at the independent claims. And then they kind of glance at the dependent claims. Now, I'm not accusing, I'm not saying anything bad about the examiners. There are some examiners that do a very thorough job, but let's be realistic. When they're doing a search and they're trying to figure out what's going on, if you have an independent claim that is very targeted and is not, overly ambitious, the examiner is more likely to actually do a more meaningful search, and at that point you get the prior art into the case that you needed to instead of later down the road, and also you're sort of giving the examiner some choices to allow the case. Now, the dependent claim should do that, but I'm just telling you, in our experience, having it as an independent claim can help bring the prosecution to close earlier, and if you bring prosecution to close earlier, you pay the lawyer less, you pay the government less, you pay everyone less. And so this can be a good thing. And spend more effort per office action. We see some clients are very hesitant to spend any resources on responding to an office action, and then they end up with 5. The better way is to spend significant resources or sufficient resources on that first office action so that maybe you only get 2 or 3. And people have done research on this that you can pay a lot less per office action, but you end up paying more overall. Okay, so that's just some observations we made. Avoiding RCEs, this is a very hot topic right now amongst all of our clients in U.S., is the dreaded RCE. They are $1,200 for the first one and $1,700 for the second one and third one and fourth one and fifth one. And hopefully you never get to 5. I've actually seen a case that did have 5. The reason I saw it was because the other attorneys were fired and it was moved to our firm. Because if you get up to 5 RCEs, there's probably something not working right. That means that you've hit a final rejection 5 times. And so, you know, you can reduce that. There are ways to do that. There's this after final consideration pilot, which doesn't cost anything in government fees, and that's been extended again by the U.S. government to 2017, so you can use that. And there's some other programs that come and go. But then we have this issue, and I don't have a real good answer. In fact, I'd be curious to you know, it's one of the things I'd like to network on and try to figure out what's the best way to go forward. And that is this cross-citation. Now, we have a duty of disclosure in the United States, right? Everybody knows you have the duty to disclose any material, any information that's material to the patentability of the patent claims. So if you file 2 or 3 applications on the same day and you get a notice of allowance on one, then you get something cited on one of the other cases, you then have to typically, most of the time, cite that information in the other case that's been allowed. Well, now since it's been allowed, you have to go through certain procedures, and you may have to pay an RCE fee. There are all these complications. It's very, very complicated. But essentially, what can happen is that you end up into a situation that we call RCE hell. And so this is where you're winning over here. You have the notice of allowance, but now you have art cited over here, either in a continuation or a brother or sister case, or in some foreign case, and now you need to keep filing these RCEs. Because the RCE is a guaranteed way to make the examiner look at the information. And if the examiner doesn't look at the information and then they don't consider it, there are all these problems with the duty of disclosure. So, and there is this new thing now called QPIDs that you can use after you get the notice of allowance, and even after you pay the issue fee, you can continue to file and satisfy this duty of disclosure. Because an easy way to invalidate a patent under U.S. law is that violation of duty of disclosure. And certainly most of our clients are very attentive to making sure that not only do they comply with it, we all want to comply with the duty, but also give the appearance that we are complying with it. We don't want to have anything that's left uncited, and that can be quite irritating at times. So I just throw that out there as one of the things that I don't necessarily have a solution for. But if you find, I mean, I've seen situations where it looks like attorneys are essentially generating revenue by just filing these IDSs one after another, and maybe there's some way to address that so that we avoid eating all the resources on filing these RCEs. So I've been negative, and I apologize for that. You know, we're trying to control costs, so a lot of us, you know, we're being negative. We're trying to stop this. We're trying to avoid this. Here's one way that actually you can have a positive effect, and that's this so-called halo effect. How many people here have heard of this? So this is a situation where you file a continuation, you file a divisional, and what happens is you prevail. Okay, you prevail on the first case. The first case gets sort of a halo on it, because now you file the second, third, fourth case, continuation, divisional. It's going to the examiner. The examiner is already aware of the art. The examiner already has built rapport with you. The examiner already trusts you because you've been able to get this first case allowed. The second, third, and fourth cases typically are more easily allowed. And I'm not encouraging folks to just go out there and file extra applications, you know, for no good reason. But if you have an area where you're targeting and you're trying to create the patent thicket, or at least some challenge, you know, cover the IP in that area with patents, this is one way to really reduce the cost, because you can file additional applications, and all you need to do is write claims. So you don't need to pay the attorney a lot of money to draft another application. All they need to do is draft the claims. And oftentimes, those cases will go through much more quickly. I have one situation where we have, you know, our third continuation now, and the examiner is continuing to allow these cases. And you can, of course, you can, you know, if there's situations where people file 10 or whatever, but it's just something to think about, because it actually reduces your cost of patent. 2 patents don't cost 2x. 2 patents cost maybe 1.25x or something like that. So, and then post-issuance, there are some things you can cut back on proofreading. There's a risk there, right? There's a case law that says that you're not entitled to damages if there's some flaw in the patent, if you don't catch it by proofreading. But some of our clients say, we don't litigate a lot. We're not interested in that. If there's an error, we'll find it later. We're not going to do the proofreading. Broadening reissue, you have 2 years, and we send reminders to some clients. Some clients say, look, we're never going to do this. Stop sending us the reminders. Patent term adjustments, very complicated. We have people that know how to do this. I myself, I can't figure out how to do the patent term adjustment because it is so complicated in the U.S. So you could just decide not to even do that because it takes so long to do it, and you might not be interested. Now, if you're a pharma, you're going to be very, very interested in the patent term adjustment, and you're going to probably have a couple people calculate it to make sure they have it right. But on the other hand, maybe you don't care. All right? And then the maintenance fees. The idea here is that you should plan to pay maintenance fees from the day you file the patent application, because they are going to be paid, or the patent is going to expire for failure to pay the maintenance fees. So if we're doing our accounting and we're figuring out how much we're going to expend on the patent, we need to project that within so many years we're going to need to pay thousands and thousands of dollars in maintenance fees. And the problem here is that if we get this giant portfolio, we're now paying thousands and thousands of dollars more in these maintenance fees. And for what reason? Do we actually have a reason to keep this? So now, the financial department comes to us and the IP cell and tells us, well, we need to figure out some way to prune the portfolio. And how do we do that? Well, if you haven't thought about it in advance, the way you do it is you go through all the applications and all the patents and you try to figure out what to do. But if you've thought about it in advance, you may already have these things ranked in some way, right? When the patent issued, you might have said, well, this was not worth very much, but we're going to go ahead and get it anyway. We want to get another patent. If you put a note there in the file to that effect, or if you have a database where you track that kind of information, when you are asked to prune, it can become a much easier exercise, right? You don't have to expend all these resources reading all the patents and trying to figure out which is which. You already have maybe half of your patents you already know have some ranking to them, and out of those you're able to take 10, 20%, and boom, you're done. You're done with your pruning exercise. So that's the type of thing where looking ahead and planning can really save you on expending your resources. And then, of course, we talked about patent valuation. You can monetize these things before you stop paying the maintenance fee, right? You could auction it or sell it or cross-license or whatever. But you may want to consult counsel about whether to keep a license, because if you do auction the patent off, you might find yourself in an awkward situation where now you've sold the patent rights and now your company is infringing and you end up being sued for your own patent that you sold to someone else. That's something to keep in mind. And these are some resources that are available to you. Certainly the PTO fee page is one that I would highly encourage you to look at if you're in the business of filing applications in the U.S., or you can just look at that slide I had where you look at the excess fees and those things. And so that's it in a nutshell, and I hope this was helpful. As attorneys, oftentimes we focused on the legal aspects. But today we focused on the cost control aspects. And to be a full-service attorney, we need to be able to do that. We need to learn how to do that and focus on that. And particularly for the new people who are coming in, this should be part of our education, is learning how to meet the client goals without breaking the budget. So thank you.
Thank you so much.
Sure.
We'll present the mementos.
Sure. Thank you very much. Right.
We break for the day, and then we again come back at 11 o'clock. Thank you. Have to make it fast because 11 o'clock we have another session. So maybe 2 questions and the rest of the questions in the networking session.